26 Meta workers say an AI ranked them for layoffs. It used their keystrokes, their screens, their emails. Some of them were on approved medical leave. A judge just let the layoffs proceed anyway. This is the court record, not a rumor. Back up to April 2026, Meta announced roughly 8,000 job cuts. That's about 10% of staff. Meta says so in its own internal memo. Meta also says about 7,000 people got redirected into new AI teams. So read that carefully. The layoff and the AI build-out are the same story. The cuts fund the machines. Here's the timeline. April 23rd, the memo. May 20, notifications begin. Workers lose system access but stay on payroll. Then July 13th, late on a Monday, 26 current employees sue. They file anonymously, as does 1 through 26. Case number 326, C712, Northern District of California. The complaint is 71 pages. Now the core claim. The complaint alleges Meta used a, quote, constellation of internal artificial intelligence systems to score, rank, and select people for the layoff. That means systems including a productivity score. The complaint says that score scanned keystrokes, screen content, emails, and browser history. It also alleges an AI native rating that measured how much you used AI tools. And here's the line that matters. The complaint alleges those inputs, quote, by design, cannot be accumulated by an employee who is on protected medical or family leave, in plain terms. If you're out having a baby, you generate no keystrokes. The complaint alleges Meta did not pause the system to adjust for that. Meta denies all of it, and I'll give the denial at full volume. Meta says the claims, quote, lack merit and are not based on facts. Workforce management and organizational decisions were and are made by people, not AI. That's the official statement. No named spokesperson. Then, the courtroom. July 16th, the plaintiff's lawyer, Barbara Cowan, told the judge, quote, there's no do-over for bonding with a new baby or giving birth or having active medical treatment. Meta's lawyer, Aaron Connell, countered that workers lose only employer-subsidized insurance, not coverage entirely. And Reuters paraphrases her arguing those losses can be recouped later in arbitration. July 17th, the order. Judge William Orrick denies the emergency request. The plaintiffs didn't show the irreparable harm that emergency relief requires. The merits go to private, individual arbitration. Some workers have already filed. But don't stop there. 3 details got buried. 1. Orrick found the 4 visa-holding plaintiffs likely do face irreparable harm because their immigration status is at risk. 2. He ordered Meta to explain by July 23rd why those 4 were picked. 3. And this is the key line. Orrick wrote that he may reconsider based on evidence about, quote, whether and how AI was used in an improper manner to cause the layoff. So this isn't closed. On July 22nd, a Wednesday, separations finalized for many of these workers. And a preliminary injunction hearing is set for August 24th. That's when Orrick could revisit everything. Now the fair countertake. Almost everything about how people were picked is an allegation. Much of it is pled on information and belief. No court has found Meta used AI improperly. Meta flatly denies it. And a job you can sue over is exactly what arbitration is built for. But 2 things are already true from the record. First, the surveillance stack the complaint describes, keystrokes, screens, emails, browser history, AI token dashboards, is the same productivity AI rolling out across the whole industry right now. Every one of those tools is also a scoring system pointed at you. Second, humans made the final decision is now the standard defense. Call it the human-in-the-loop fig leaf. And a federal judge just said he wants to see whether and how AI was actually used. If your company just deployed productivity AI, understand this. Your token dashboard is not your friend.